We have a brand new indictment in the Sean Combs criminal case, and did we just get a clue as to who may be an important witness at an upcoming trial? We're going to break that down for you and more right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Okay, so we have a bunch of updates in the Sean Combs criminal case out in New York. First up, we have a brand new indictment. This is a second superseding indictment, meaning this is the second revised or amended indictment in this case. The first superseding indictment was back in January. Now, I gotta give a caveat here. Before you think that this is naming new defendants or new charges against Sean Combs, I'm gonna read you the letter to the court from Matthew Podolsky. This is the acting United States Attorney for the Southern District of New York. It was filed in conjunction with the second superseding indictment. This lays out what the indictment says and what it doesn't say. It reads, "Dear Judge Subramanian, the government respectfully submits this letter regarding the S2 indictment returned today in the above referenced case by a grand jury sitting in this district. The S2 indictment contains no new charged offenses, but includes additional allegations related to the racketeering conspiracy charged in count 1. Specifically, the S2 indictment contains additional allegations as to the means and methods of the racketeering enterprise related to forced labor." Okay, I'm going to stop you right there because before I go any further into this letter, I want to go directly to the second superseding indictment, and I'm going to read for you now what appears to be the only change, this one new addition. Again, this is under the means and method of the criminal enterprise that Combs allegedly led and ran as part of the racketeering conspiracy charge. Remember, this criminal enterprise that prosecutors allege engaged in forced labor, sex trafficking, arson, kidnapping. And we remember what the main central allegations are about this racketeering conspiracy, that Combs allegedly engaged in a pattern of abusing women for years, verbally, emotionally, physically, sexually, that included transporting women and commercial sex workers and coercing and forcing women to participate in sex acts for his own desire, that he would use drugs or threats or power or influence to get them to do this, to get them to do what he wanted, that he used his power, his resources, his business empire, employees, associates to carry out this alleged criminal activity, including having them cover it all up. And all of these practices are violations of law. So this is what the new paragraph in the second superseding indictment reads, quote, "Combs, along with members and associates of the enterprise, also maintained control over certain employees of the Combs business, whom he forced to work long hours with little sleep through use of, among other things, physical force, psychological harm, financial harm, and reputational harm and or threats of the same. In doing so, Combs, assisted by members and associates of the enterprise, caused these employees to believe they would be harmed, including by losing their jobs if they did not comply with his demands. With respect to one employee, Combs used physical force, psychological harm, financial harm, and reputational harm and or threats of the same to cause the employee to engage in sex acts with Combs." All right, I want to thank our sponsor, Odoo, who's been with us as we are continuing our coverage of Sean Combs. Their support helps make episodes like this possible. Now, Odoo is an incredible all-in-one business management software that provides you with a range of applications. One of my favorite Odoo applications is their website builder. So with their drag and drop feature and AI copywriter helping me come up with website descriptions, I was able to build, for my other show, Prime Crime, a website in literally minutes. I mean, look at this beautiful website. I mean, look at this website. Look how beautiful that is. primecrime.com. How cool is that? So thanks to Odoo for sponsoring Sidebar and getting me a Prime Crime website. And build your website now, too. The domain is free for the first year when you use our link, odoo.com/sidebarweb. We do not know who these employees are or who that specific employee may be. If you ask me, maybe a couple weeks ago, I thought I could have made an argument if this came out then. Maybe it could have been Rodney Little Rod Jones, Combs' former producer who filed his own sexual assault lawsuit against Combs, maybe was cooperating with the government, but what happened? We know in a recent filing from Combs' defense attorneys, they seem to suggest that Jones is not a key witness for the prosecution anymore. In a recently filed motion, Combs' lawyers wrote, Some of the most salacious allegations recounted in the warrant applications came from producer one, so we're surmising maybe that was Jones, who the government now says it will not even call to testify at trial. The investigator indicated he had interviewed producer one, and producer one had relayed stories about his time working for Combs, and the exact details of what producer one told the investigators is redacted, but the defense went on to say these accusations were never credible, they were uncorroborated. And the filing continues. The government has advised us it will not call producer one as a witness at Combs' trial. Presumably that is because his stories are fantastical and he lacks any credibility. Okay, so assuming this is not, in this superseding indictment, the second superseding indictment, assuming this is not Rodney Jones, and assuming the defense is accurate about that, you put that to the side, who else could this be? Who else could they call? Who was an employee or employees of Sean Combs' empire that might be, described here? Well, I got to say, look, I have a potential idea. I have no way to confirm this, but a potential idea, when I heard about sleep or a lack of sleep, I was reminded of one specific lawsuit, a lawsuit filed by Dawn Richard, the former member of the musical group Danity Kane. She accused Combs in a lawsuit that was filed last year of sexual assault and being a witness to Combs allegedly abusing his ex-girlfriend, Cassandra Ventura, who we believe is an alleged victim, possibly victim number one in the indictment, who we believe is going to testify at this criminal trial. And remember, she was the person who initially filed a lawsuit back in 2023 against Combs that arguably started this whole legal mess for him. But also, another reason she may be an actual witness in this criminal trial is if Ventura is in fact victim one as laid out in the indictment, this is going to be a key witness to corroborate Ventura's account. But Dawn Richard claims in her lawsuit, going back to the idea of sleep, that Combs deprived her of food and sleep. Well, let's go back to what she said in her complaint that was filed in September of 2024. It reads, quote, "Throughout the productions of Making the Band 3 and 4, Mr. Combs deprived Miss Richard and her Danity Kane bandmates of basic needs such as adequate food and sleep. When Miss Richard or her Danity Kane bandmates requested meals or rest, Mr. Combs refused and chastised them with derogatory comments like, 'You bees don't want this,' or 'You're all not hungry enough and I'm paying you bees to work.' This demeaning behavior gradually undermined Miss Richard's confidence and contributed significantly to her growing feelings of insecurity and fear of reprisal from Mr. Combs." And the complaint went on to say, forced to choose between eating and sleeping, Miss Richard lost a significant amount of weight, weighing approximately 100 pounds at a height of 5'4". Miss Richard began to normalize these extreme conditions and perceive them as standard requirements of her participation in Danity Kane. And then there's this, quote, "Mr. Combs regularly sent his associates to wake Miss Richard and her Danity Kane bandmates in the overnight hours so he could watch them rehearse. The regularity of these disturbances led Miss Richard to adapt by sleeping in a sitting position, fully dressed and with makeup on, heightening her anxiety. Over time, this abnormal sleeping arrangement came to feel routine, further normalizing Mr. Combs' invasive demands." So, is it possible that this is all in reference to Dawn Richard? Maybe. Although I will tell you, she didn't, in her lawsuit, necessarily allege that she engaged in sex acts per se with Sean Combs. She said that he assaulted her. Although I will tell you, she did indicate in her lawsuit that Combs' assistant, so an employee, engaged in group sex with Combs and other men. But why add this specific paragraph in a superseding indictment, right? Well, maybe supporting her potential testimony as a key witness in the case, or whoever will testify. And what you are seeing, though, is how much prosecutors may be relying on forced labor to support their underlying racketeering charge. Remember, this is the main charge of this case. It's a charge that carries potentially up to life in prison. So they really, really want to get Sean Combs on this. And in order to get to racketeering conspiracy, count one, prosecutors need to show underlying crimes to get to that charge, need to show the criminal enterprise. What were the illicit activities this alleged criminal enterprise were involved in? And forced labor may be a more straightforward way to get there. And to give you an idea about what we're talking about with forced labor, this is how it's defined under the United States Code. whoever knowingly provides or obtains the labor or services of a person by any one of or by any combination of the following means, by means of force, threats of force, physical restraint, or threats of physical restraint to that person or another person, by means of serious harm or threats of serious harm to that person or another person, by means of the abuse or threat and abuse of law or legal process, or by means of any scheme, plan, or pattern intended to cause the person to believe that if the person did not perform such labor or services, that person or another person would suffer serious harm or physical restraint. Now, going back to Podolsky's letter to Judge Arun Subramanian that was filed in connection or in conjunction with this superseding indictment, it goes on to say, quote, "The government expects to provide defense counsel with a supplemental enterprise letter related to these allegations by March 10th, 2025. Now, we've talked about this before. An enterprise letter is something we believe has already been filed in this case under seal, meaning we can't see it, but the defense has. And it's usually filed by the government in RICO, racketeering cases, that it more specifically lays out the exact allegations in the racketeering or criminal enterprise charge, what evidence the government seeks to introduce to prove that, the specific underlying acts or events that make up that racketeering charge, probably filed under seal here to ensure that details about the alleged crimes, the potential alleged victims and witnesses identified are all not revealed before trial, because obviously that could negatively affect the case in some way. And now the United States Attorney's Office seems to have indicated they will provide a new additional supplemental enterprise letter that will lay out this more specifically for the defense about this forced labor allegation. But again, we will probably not see it. And I'll tell you what, I want you to keep that in mind, because we have something more to talk about with this, something in relation to what the judge just did. But before we get into that, I want to finish up this letter from AUSA Podolsky. It says, quote, "The government has already produced Rule 16 discovery associated with the S2 indictment and does not expect the S2 indictment to affect existing pretrial deadlines. The government respectfully requests that the defendant be arraigned on the S2 indictment at the conference scheduled for March 14th, 2025. So Rule 16 of criminal procedure governs the disclosure responsibilities of prosecutors, including, if requested by the defense, the government has to produce documents and items that are material to preparing a defense that are in the possession, custody, or control of the government. And they indicated they don't believe this is going to affect pretrial deadlines or seemingly the trial date of May 5th, 2025. Maybe because, this additional evidence, this additional discovery, not going to affect the defense's ability to prepare adequately for trial. But they request that Combs be arraigned in court on March 14th, when seemingly there was already another conference scheduled, and that's where he'll be advised of his rights, the charges, most likely will enter a plea. Nothing major here, more pro forma. But Mark Agnifilo, who is an attorney for Sean Combs, denied these allegations in a statement to Variety and remarked that, quote, "Many former employees are basically willing to stand up for Sean Combs." He said, quote, "Combs looks forward to his day in court when it will become clear that he has never forced anyone to engage in sexual acts against their will. Many former employees stand by his side, prepared to attest to the dedication, hard work, and inspiration they experience while helping build groundbreaking, award-winning businesses." So maybe kind of gives us an idea of who he will call as potential witnesses for the defense. And look, this is all interesting because it ties into what, honestly speaking, we were planning on talking about, what our episode was going to be about today before all the news broke of this superseding indictment. So let me just lay out what happened as well. I mentioned there's multiple issues going on in the Sean Combs criminal case. So now we have the resolution of an issue that has been months in the making. Judge Arun Subramanian just issued a ruling on whether or not Sean Combs can know the identities of anonymous victims and witnesses in this case. Now, before we even get into what the judge's order is, let's first understand the arguments and the history that led up to this. So now we got to go all the way back to October, when Combs' attorneys filed a letter requesting the court, pursuant to the Federal Rules of Criminal Procedure, to order the prosecution to identify the alleged victims in this case. And they argued they have to know who these people are in order to properly prepare for trial. What they asked for specifically was a bill of particulars. That is a written statement outlining more details about a charge or charges that a defendant is facing. We see this come up a lot in terms of a criminal defendants' rights under the Sixth Amendment, namely, quote, to be informed of the nature and cause of the accusation. And here, Combs' defense argued that they need a bill of particulars. It becomes especially important in a racketeering or RICO case because that charge can be quite broad. It can encompass a lot of different alleged criminal activity and underlying acts. So there is perhaps a need to particularize that more so in this kind of case than in other cases. They need specificity about what is being charged, what is being alleged, and so forth. In their October letter, Combs' defense laid out several reasons for this. For example, they wrote, "Without clarity from the government, Mr. Combs has no way of knowing which allegations the government is relying on for purposes of the indictment." Meaning Combs is facing so many different sexual assault civil lawsuits that we don't know if or what from those suits the government may be using in the criminal case. Also, they argued, given the anticipated amount of discovery and the expected time required for its production, Mr. Combs will be unable to adduce the identities of the purported victims from the discovery without the assistance of the government. Mr. Combs also anticipates that the discovery will contain voluminous evidence of consensual sexual activity, making it all the more difficult for Mr. Combs to ascertain which of his prior sexual partners now claim, years later, that they felt coerced. Even if it were possible to ascertain the victim's identity from the discovery, and especially given the volume of anticipated discovery, it's unfair to require Mr. Combs to spend significant time trying to unearth the alleged victims' identities. Now, first they argued, quote, "Courts routinely reject requests for victim identities in cases involving crimes of violence and racketeering, especially when the government demonstrates a risk to witness safety, the potential for witness intimidation or subornation of perjury." And here, the prosecution argued there is, quote, "serious, well-supported allegations of prior attempts to obstruct and tamper with witnesses." And in fact, they cited the ruling of a prior judge who denied Combs bail, having, quote, "found by clear and convincing evidence at the conclusion of the second hearing, the defendant," meaning Sean Combs, "is a danger regarding obstruction of justice and witness tampering and is a danger to the safety of others in the community more generally." And we all recall that prosecutors have alleged that Combs tried to improperly contact witnesses while in federal lockup in the Metropolitan Detention Center, the MDC, where he's actually been housed since his arrest and indictment in September of last year. And as reported by outlets like NBC, there was also the allegation that he tried to influence the account of a potential witness in the civil case of, again, Dawn Richard, someone who may be a key witness in this criminal case. So the government is basically saying he can't know the identities of the victims. And the government wrote in its October opposition, due to the defendant's history, the government has serious concerns about victim safety and the possibility of witness tampering if a list of victim names were provided to the defendant. And then the government argued, you don't even need a bill of particulars listing victims' names here, Sean Combs, because you have already been sufficiently apprised of the nature of these charges based on the indictment, the government's submissions and papers, mountains of discovery, including digital material, search warrant affidavits, so forth. And they argue that as a matter of how courts have resolved these bill of particular issues in the past, we should win. And this was what they wrote. When a defendant seeks victim identities through a bill of particulars, courts generally deny disclosure if the government sets forth specific reasons why such a request should be denied. And based on everything that I just mentioned, they clearly believe they did that. And then they presented another interesting argument that granting a bill of particulars would negatively affect their case at trial. Quote, "The defendant's request would also have the effect of improperly foreclosing the government from using proof it may develop as the trial approaches." And the reason for that would be because a bill of particulars essentially confines or arguably confines the government's proof to the particulars that are furnished in that document. In other words, the government's presentation of evidence at the trial would be limited to what is laid out in that bill of particulars. And the argument is this can improperly restrict the government's ability to present its case and from using evidence as this investigation continues. Now, that was all back in October. Now we fast forward to what happened just last month, because Combs' team filed another letter now saying they want witnesses' names, not just alleged victims' names, witnesses' names. They wrote, "The government has produced over 20 terabytes of information, and it is impossible to do a proper defense investigation as to the allegations in the Enterprise letter in less than 2 months without the names of the individuals, both alleged victims and potential witnesses, who are listed in the enterprise letter. And so they requested a bill of particulars related to victims' names and anonymous witnesses as laid out in that apparently sealed enterprise letter. Who are these people? In other words, the defense is saying we need more details about the racketeering charge and what the prosecution plans to do, and they argue we still need to know who these people are. And the prosecution responded. They have continued to object to this, arguing in their filing, quote, premature identification of victims and witnesses carries significant risks in a case like this one, which involves numerous allegations of violence, coercion, obstruction of justice, and witness tampering. Again, they highlighted how the defense has enough already, writing, the defendant has received substantial additional disclosures, including terabytes of Rule 16 discovery, which I mentioned before, which provide him with more than sufficient information to prepare for trial. The government provided the defendant with a 16-page enterprise letter outlining in detail the racketeering activity and related conduct that the government currently expects to prove at trial in connection with the charged racketeering conspiracy offense. The enterprise letter described these acts in detail, including their approximate dates and the people involved, noting, for example, their titles at the defendant's company or providing other identifying features. In short, these additional disclosures undermine any claim by the defendant that he is not aware of the nature of the charge pending against him or is unable to adequately prepare for trial. And they argue that Combs has provided no adequate basis for this request. His motion should be denied, especially because the government says, hey, look, we're already required to provide this information pursuant to a pretrial disclosure schedule. That's going to happen already. And I want you to keep that in mind. We're going to talk about it in a second. By the way, I also have to call this out. It's interesting, considering we have this new superseding indictment. There was a footnote in their letter from last month that read, quote, as previously communicated to the defendant, the government will supplement the enterprise letter in the event that additional incidents are identified or if the government obtains additional material information about the conduct described. And again, they just wrote to the court in their newest letter they plan to do that in light of the superseding indictment, offer a supplemental enterprise letter. So what did the judge decide about all this? Will Sean Combs know the identities of these people? Well, Judge Subramanian's order reads as follows. Combs asked for the identities of the anonymized victims and witnesses identified in the government's RICO enterprise letter, reprising and expanding his October 2024 motion for a bill of particulars for victim names. The government doesn't oppose disclosure of this information. It makes clear that it plans to turn this information over to Combs on March 21st, 2025, the date on the schedule for the government's disclosure of 3500 material under an attorney's eyes only designation. 3500 material, it's basically about statements and reports of government witnesses. Subramanian continues, because this dispute has narrowed to whether disclosure should happen now or in a couple of weeks, the interests that would normally counsel against immediate disclosure have abated. The government has the information, doesn't identify any logistical issues in turning it over earlier, and in fact, plans to do so shortly, minimizing any concerns about witness tampering and the like based on advanced disclosure. On the other hand, Combs emphasizes that there is a tremendous volume of information that has and will be produced, and every day counts for preparation with trial 2 months away. For these reasons, and balancing the parties' interests, the court grants the motion and orders the government to provide the requested information under an attorney's eyes only designation, meaning Combs' attorneys can see it, but possibly Sean Combs himself will not see it, on or before March 10th, 2025, 3 days from now. And then it says the clerk of court is respectfully requested to terminate docket 36. This was Combs' original October letter. So Combs' team is going to know who these important people are in this case. Will that include Dawn Richard? We do not know. But just a very interesting development happening in the criminal saga of Sean Diddy Combs. That's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.